this multiple executors is something new, because as you rightly said, most advice that we have got is that there should be only one.
Hold on.
Yeah,
I
yeah.
might forget. Please hold
Yes,
on.
sir.
When you
Yes,
are appointing executors, 2 or 3
yes,
or whatever it is, please
yes.
also give them the right to appoint other executors if they want to.
Right, sir.
That's a
Okay,
very
all right.
important thing which I had forgotten.
Understand.
So
Understand.
they have the right to appoint other
Right.
executors, because your
Understand.
executors might become old or they might not be able to do it. They can. So please get that clause in also. I'm sorry to disturb you. Now please
No,
continue.
not at all. So, so the two interesting, deviations or learnings from what our understanding was about about, I think that is a myth that, that beneficiary should not be executors. So, thank you for clarifying that. And then there was also the point about, appointing multiple executors where one or more of them could be beneficiaries and one or more of them could be non-beneficiaries. My question to you, sir, is in that situation where there are more than one executor, and in case, for any reason, there is a disagreement between them as to who effectively should execute the will, how does that get resolved, sir? Can that itself go into some kind of dispute or a debate where, two executors are at loggerheads with each other?
Mr. Latkani, your question has answered itself. That is
Right.
why the beneficiary is put in.
Okay.
Because it's
Okay.
in his or her interest to execute it.
No. If both of them want to execute it, then what happens?
Okay, there are 2 beneficiaries, right?
Yes. Yes.
Both of them do not want to execute it.
Do want to execute?
Then go ahead and execute it.
Okay. Jointly, it can be done.
Jointly, yes, obviously. You,
Right. Okay.
if
So
there
there
are
is no
two,
conflict.
if there are 2 executors, one cannot go to court. The other one has to go to court with him or her.
I see. Okay.
It
And
can
if
be
one
done.
refuses to go, the other person can go and say
Yes.
that the other
If the
person has
person
refused. So I
refuses
have.
himself, yeah, then the other person can go to the court
Right.
and do it.
Okay.
But,
Okay. Okay. So there is no conflict in terms of having multiple executors.
no,
Right.
see, a lot of people, I'm 81 years old. When I draft a will, they say, I want to make you my executor. I said, how do you know that I'll outlive you?
Right.
You are maybe
Right.
50 or 60. How do you know I'll outlive
Yes.
you? So
Of
please
course.
pick some executor who is
Yeah.
younger than you are, who is
Yes.
quite capable. Another thing, the executor must be capable. He must
Right.
understand a little bit of the law. I
Hmm.
mean, if he's totally illiterate, it would be extremely difficult for him to execute it. But
Of
I
course. Of
believe
course.
that having the beneficiaries, it solves a lot of problems. It is in
Right.
their interest to do it. And if anybody wants to act nasty, say that, please, you recuse yourself. We know what to do.
Right. Understand. All right, sir. Thank you very much.
Next question.
Sir, if property is not self-owned but got as a being a heir from grandfather or father through will or otherwise, then can it be given in will?
I presume you are a Hindu.
Yes, sir.
And if you're talking of ancestral property,
Yes, sir.
self-acquired can be willed.
Yes.
What you have inherited, and if it's in a joint family, then obviously it cannot be. Unless, of course, the Karta has got the right to do it, liquidate the assets under certain circumstances, maybe financial
No,
or
but if it is not HUF property, but maybe, suppose my grandfather had given me share of property along with maybe my brother or my uncle, then can I will it?
Yes. If it's not an HUF and it's as simple as a succession, why should you worry
As a
about it?
succession, if I have got through succession or will, can I will it?
If it is self-acquired, it is. If I buy something, if I buy a pen, why can't I give it to anybody else I want? Maybe to my grandson or my great grandson. It's immaterial.
No, but it is not self-acquired by me. For example, if it was given by my father to me, I got it as a successor.
But your
Not
father
through
gives
will,
you
but as a
something that
successor.
As long as
your father gives you something which he is acquired himself. It is his. I told her, she says it's not HUF. It is not HUF. She's agreed that it is not HUF. See, if your grandfather has bought a Parker fountain pen for 10 rupees, which is now worth 10 lakhs of rupees, it's immaterial. The item is his. He's giving it to you. He has every right to give it to you. In fact, if you want to take a real test of it, if you want to take a real test on these things, we know that the final test of property is the right to destruct. There cannot be a greater right to property than the right to destruction. Now he buys a pen for 10 rupees. He uses it for 50 years. He can just break it up and throw it away. No one can tell him not to do it, which means it is his own. It might be worth 10 lakhs of rupees today. If he sells it, he might have to pay some tax on it. He gives it to you. Who is there to dispute it? It's yours. I mean, it's his. He's giving it to you. It becomes yours.
Now I can give it to someone,
Yes, yes.
even if it's a immovable property.
See, your grandfather is alive. He has got this Parker pen costing 10 lakhs of rupees. You know that he has willed it to you, and you know that one day it is going to come to you, but you are not sure whether you will outlast your father. And you have a son. So in your will, you write the residual clause that anything else that I might get, because when you are writing your will, the pen does not belong to you, but you know it's going to come to you. So that is why if you remember, I said about the residual clause earlier. It's an
Yes, sir.
important clause. So what you do is, in your will, you write that anything else that I might receive in future from anywhere, whether it is from my father, whether it's from my grandfather, or whether it is from the government, they might give you some pension or whatever it is. You might get something. That is the residue which I also want to go to my son. So if you predecease your grandfather and your grandfather is left, of course, there's a possibility of one thing. If you predecease your grandfather, he might change his will. He doesn't want to give it to your son. He only wanted to give it to you.
Yes, sir.
That possibility exists. But best thing to do is to put in a residual clause and say that whatever I have, I want to give it to my son or my son and daughter. And any residue would either go to my son or to my daughter or to a charity or distributed equally or distributed 75%, 25% between so and so people. Put in that residual clause so that everything, anything not mentioned in the will is included in that.
No, agree, sir. I'm not talking about the residual clause, but already maybe my father has passed away. He has given, I mean, I got some of his immovable property
Yes,
as a successor, I mean, as a heir,
yes.
and can I dispose it off?
Of course you can. It's yours.
So then where is the question of, like, waiting for 3 generations and all, some people say.
But then your father could have disposed it off. Who says you have to wait for 3 generations? I didn't say that.
No, you didn't say that, but I mean, many of the webinars and all I heard. So
I
that's why
don't think.
I wanted to clarify that.
In law, please remember one thing. Please remember one thing in law. There is what is prescribed and that what is proscribed. Anything that is not proscribed is legal. I am wearing a yellow t-shirt. But if the law says I can't wear a yellow t-shirt, I can't wear it.
Okay.
But if the law does not say anything, I can wear any color that I want.
Okay.
So try to distinguish what is prescribed and what is proscribed.
So if it's an ancestral house, which I'm also a part of it, my father has passed away, I have a right to give my share to whom I want, right?
Yes, you also have a right to occupy the house.
Yes, sir. If deceased son's wife remarries, if somebody's son has already passed away and his wife remarries, she will have right in father-in-law's property.
If the father-in-law has made a will, the son dies. The father-in-law's will, whether he wants to give it to his daughter-in-law or not, is left to the father-in-law.
But if it is
If he
not
says
made will,
he's not made a will.
Yeah,
Yes.
intestate.
Now which religion is it? Hindu?
Hindu,
She
Jain.
would have a right
Yeah.
as the husband. She would have a right as the wife of the husband.
Even if she remarries.
Originally that did not exist, but now women are getting more rights.
So
Originally,
even
that
if she
did not exist.
remarries someone else,
Yeah.
also she will have right.
Of course, she would not only have this right, she would have the right of a second husband also. I know it's a very dicey thing. People don't want a widow to marry again. There were reasons for that, but the laws are now being changed to get rid of that mental block. We are becoming a little bit more sensible. I won't use the word liberal, but becoming a little bit more sensible. This used to occur. In fact, if you really want to go back, what was sati?
Yes.
Sati was, the idea was that the widow doesn't get anything because she's dead.
Yes.
I mean, when society evolves and you want to be fair, I mean, what's wrong in a widow remarrying? People don't like it. I know that they don't like it. Some of them might even encourage it, but it is hers. She married the man, her husband. Why should she not get what is rightfully his?
Okay.
I'll tell you what would happen otherwise. If the law did not exist, would you have been happy if the woman lived in sin? Suppose she's a young widow, very young widow. She has got a child. She wants somebody to look after herself and her son or maybe 2 children. You don't allow her to marry, telling her if you get married, you won't get anything. Would you prefer it if she lived in sin?
No. No, this
Laws,
is the situation in one of the relatives, so
it
that's why
happens
I'm asking.
not
Yes,
one.
sir.
It happens in 100, not one.
But
We find
like
it very
from now from the other perspective, now not from the widow's perspective, but
Yes.
suppose in case father-in-law doesn't want her to get the, so then can she, I mean, he get the
Yeah,
release
yeah.
date done by her?
He can drive her out of. He can. Only thing is he cannot drive her out of the house because the laws are.
No, she
The
has
laws
already
are
remarried. She has already remarried. But I mean, can she sign a release deed and then relinquish her right?
But why a release deed if the father-in-law does not want to give it to her? He won't give it to her. Where is the question of release deed?
No, no. By law, it will go to her in case father-in-law dies intestate.
Yes, yes. No, if it is HUF, it won't. But if it is
No,
not
not
HUF,
HUF.
it's a clean property. It will go to her if the father-in-law, because through the son, it will go to the wife. Even if she marries 10 times, it will go to her.
Okay. Okay, sir. Thank you.
Yeah,
In
good
fact,
afternoon, sir.
you have given me
One thing,
clarity.
if there is
You have
any
given me
problem like
clarity about the law.
one thing, if there is any problem like this, these problems are going to occur. And especially after COVID, everybody has realized the need for writing a will. So
Yes.
they are going to occur. And there will be prejudices everywhere. Everywhere there will be prejudices. Maybe the husband's brother tells the father, don't give it to her, give everything to me. That can also happen.
Yeah, that is true, sir. It might have happened in their family.
So we guess right?
Yes, sir.
We guess right. Okay, next.
Yeah, my first question is, sir, when you said I'm of sound mind and I'm executing this will, can that be challenged in the court of law?
Okay, whatever it is, you live in a democracy.
Yeah.
And I always say that we live in a democracy where anything can be challenged. No one can keep. The Constitution allows you to go to the court of law. The Constitution has got 3 or 4 articles which says that you can go to the court of law. No one can stop you from going to the court of law. Even if you know you are in the wrong, you can go to the court of law. Even if you know that you are making a nuisance of yourself, you can go to a court of law. Nobody can stop you from going to the court of law. Everybody has a right. Multimillionaire, pauper, whatever it is, has a right to knock on the doors of the law. Fortunately, these days, courts are coming down heavily on frivolous litigation. But no court will stop you.
Can you make something like attach a doctor certificate saying that on this date,
Please do,
this
please do,
person?
please do. That is why a lot of people like to have the doctor as the witness, which says that I had examined the testator and was in sound mind. It can be done. In that respect, a handwritten will, a holographic will, would have greater effect than a typed one. If your handwriting is clear, if your handwriting is not clear, please don't write a will. Have it typed out. But if your handwriting is clear, a holographic will be the best thing, because a person of a sound mind would only be able to write all these things. So holographic will would be the best thing. If you can't, a doctor's certificate attached would be an additional proof that the testator was in sound mind, sound good health. Now, good health doesn't mean that if I've broken my leg, I can't sign a will. A good health would be I'm capable of at least signing the will. A good health would be I'm conscious, which of course means sound mind. So these sort of things. That's why I say please make a will as fast as possible. Don't wait for the last day. You might not be able to execute it.
Okay. Yeah, my second question is, sir, regarding the undue influence. Most of the time we come across where the mother is staying with one of the sons and he makes a will in his favor, taking all the care that, okay, my son number two will not get anything. So is there any defense available for the second son to say that since my mother was living with my elder brother and he had an undue influence on her, and because of that, this kind of will has been structured. So can it be challenged? And what are the
Sir,
defenses available?
50% of the cases are like that.
Undue influence.
I had not necessarily. Why do you say undue influence just because it is given to the son? Yeah, I had started this seminar by mentioning this sort of thing. Why do you assume that because it is given to the son who is staying with the mother, it is incorrect? Why can't you assume that it is correct?
Okay.
Tell me, answer
So,
me. Why do you assume that it is incorrect? Just because he's
o-
staying with the mother and looking after the mother and the mother gives it to him, does it make it incorrect or illegal? That is
okay.
why when the witnesses are signing, they know that it is the duty of the advocate. This is what now I remember. This is what I told you at the beginning of the seminar, that you have to find out as an advocate. Don't go if somebody comes and tells you make my mother's will and she's giving everything to me, or even giving everything to my sister or my brother. Please don't. You must be present and discussing the matter with the testator. Without the testator being influenced in any, the testator must be alone. I told you about my own cousin. I refused to draft the will because his wife insisted on sitting while we were drafting it. I refused. Suppose the children went to court and I was asked to come to the court. I would have had to say that yes, the wife was sitting there. Then somebody will say, why was she sitting there? She must have influenced it. So please, anything more? Have I answered your question, sir?
Yes. The answer, the last question is regarding the deficiency of the executors and witness. Say, for example, if the person dies, he has a will, and before executing the will, the witness also dies, one of the witness. Then what happens to it? Because it has to be
That is
signed by.
we have been through this earlier. I don't think you are paying attention. We have been through this. You have 2 or 3 executors or executrix. If they are beneficiaries, please make them the executors executive, and also have a clause whereby the executor can uh, appoint other executors. And we have also discussed this fact that please don't keep the same people, same family group. All of them might die together in a plane crash, to keep them at arm's length. I think you were not there when we discussed this. So please, 2 or 3, 1 or 2 of them must be the beneficiaries, so that if others drop out, the beneficiaries can get the probate. We've been through all this, sir.
So, Mr. Malcolm, I think he can watch the webinar when it's uploaded on YouTube. We'll move on to the next participant.
Sir, whether any cooperative society can refuse to transfer the property without
They
the
should.
probate?
They should. The proper society has got no right to transfer properties. Who are they to transfer properties? What right do they have? A society is a group of elected people to run the society, not transfer properties. They can sit on properties like judges do. I know कि 25,000 रुपया भरो हम तुम्हारे नाम पे करके देता हूँ. That's wrong.
But probate is compulsory only in 3 places, na? Mumbai, Kolkata,
Yes,
and
but even suppose you are in some village and there is a will and there is a nomination. What should the society do? Let me put it that way. What should the society do?
Yeah, to safeguard their interest, they should ask for the probate.
Not in a probate administration. There are no probates.
Yeah, for the villages. Yeah. So that will be letter of administration.
Yes, you can go to a court and get it done. Alternatively, one easier way to do it would be, now suppose you are the testator and I am the beneficiary. And there are 3 or 4 other people close to us. Say my brothers, my sisters, maybe your children, etc., who may have a right to your property. As a lawyer, I would give them notice that this is the will. This property by this lady, the testatrix, has given it to me. Do you have any problem? I would start with that notice. If they have a problem, we either sort it out or go to court. Let the court decide. If they don't have a problem, I would still take another step. I would give a public notice. Suppose I am not aware of some relative or the other who could have a share. So I would give public notices in 2 newspapers, in English and vernacular, or maybe 2 vernaculars, but whatever it is. I would do that. But I would not hurry the transfer of property. Because if you hurry the transfer of property, eyebrows will be raised. You are enjoying the property, you are sitting there, you are paying the taxes, you are paying the dues, whatever it is. But don't be in a hurry to get it transferred. Go through the process. As many processes as you think are possible. Finally, you take all that bunch of papers and go to the society and say, look, I've done this. If you want me to do anything more, tell me what do you want me to do. Otherwise, please transfer it. If you don't transfer it, I'll go to court and get an order against you to transfer it.
So if the property is given by will, transfer deed has to be executed.
If the property is given by will, what did you say?
The transfer deed has to be prepared. to get that property in transferred in the beneficiary's?
After you go through this exercise, I would not suggest you go to the society and tell the secretary that transfer will be on the basis of this will. Who is the society secretary to even decide whether the will is correct or not, whether it is a forged document or not? Who is he? Suppose you give it to your son. I am one of your sons. You have given it to son one, and I say that this will is forged. What happens?
True,
Will
very
the
true, sir.
society secretary take it on his head? I know the society secretaries think that they are gods. They are not. They are servants. Please make it very sure to any society secretary who does that. You are elected for a year, 2 years, and you are a servant of the society. Your business is to manage, not to distribute. Be very firm on that. Unless, of course, you want it to be transferred to yourself.
No, no. On the will, if names of 2 witnesses are mentioned, but it is signed by only 1 witness, the second witness's signature was not taken, and the will invalid. So it can be challenged.
I would not even suggest you go to court with it. It'll be thrown out.
No, but then if the executors try to execute the will, then will have to be challenged. No?
It is as good as intested. It means no will. Full stop. It's a piece of paper. Tear it up and throw it away.
Okay, sir.